Hello and welcome back to Deep Dive Daily. It is fantastic to have you with us again.
It's a pleasure to be here.
We are diving straight into the deep end today. We've got a stack of legal texts, some pretty intense historical debates from the 1940s, and, well, a pile of heavy Supreme Court judgments on the table.
We certainly do.
And the goal today is to strip away the noise of daily politics and really look at the operating system running underneath the Indian state.
And, operating system is a great term for it. We are looking at what the historian Granville Austin famously called the conscience of the Constitution.
That is a heavy title, the conscience. But we aren't talking about fundamental rights today, are we? That's usually what people mean.
No, we're talking about the other part. Part 4 of the Constitution of India, that's Articles 36 to 51, the Directive Principles of State Policy.
Or DPSP for short.
Exactly. And this is where the immediate tension lies for anyone studying Indian law. When most people think of the Constitution, they think of Part 3, fundamental rights.
Sure. Free speech, equality, right to life. The big ones.
Right, and if the government violates those, you can go straight to the Supreme Court. But Part 4 it's different. These are instructions to the government that, strictly speaking, you can't enforce in a court of law.
And that is the hook for this whole deep dive, isn't it?
Mm-hmm.
It's like having a rule book that says you must do X, Y, and Z to make the country a paradise, but then, adds a little footnote saying, but if you don't do it, nobody can sue you.
It creates this massive paradox.
Exactly. Are these principles just pious aspirations? I think a critic called them a check payable when able. Or are they actually the soul of Indian democracy?
That is the mission today. We need to unpack Part 4, not just as a wish list, but as a legal instrument. We have to understand the origins, the framework, the huge legal war that broke out between Parliament and the Supreme Court over these principles.
And then finally look at the receipts. The actual acts and laws that prove these principles are, alive and kicking.
That's the plan.
Okay, so let's start at the beginning. The origin story. I know the standard trivia answer is that we borrowed this idea from the Irish Constitution of 1937.
We did, that's true. The Irish Constitution had these directive principles of social policy. And if you want to get really thorough, the Irish actually copied the concept from the Spanish Constitution.
So there's a lineage there.
There is. But for India, Dr. B.R. Ambedkar, who was the chairman of the drafting committee, he had a much more specific vision. He didn't just see them as a copy-paste job. He called them novel features.
Novel feature. Okay, why? Novel. What was he trying to do that was so different from, say, the Irish or Spanish models?
He was looking at India's immediate past under the British Raj, specifically the Government of India Act of 1935. Now, under that colonial system, the British government would issue what they called an instrument of instructions.
An instrument of instructions.
Yes, to the Governor-General and the governors of the colonies. These were basically guidelines from the empire on how to run the administration.
So a top-down to-do list for the colonial rulers.
Exactly. And Ambedkar's argument was that the directive principles are, and I'm paraphrasing here, merely another name for that instrument of instructions, but, and this is the crucial shift, the recipient changed. Wow. The old instructions were for British governors controlled by London. The directive principles are instructions to the legislature and the executive of a free, independent India.
That's a really powerful reframing. It's the Constitution itself handing the instructions to the future governments of India.
Precisely.
And just to be clear, when we say the state has to follow these instructions, who exactly are we talking about? Because Article 36 defines state.
Right, and that's an important clarification. Article 36 says that state has the same meaning here in Part 4 as it does in Part 3 with the fundamental rights.
Okay, so what does that mean in practice?
It means it's not just the Prime Minister or Parliament. It includes the government and parliament of India, the government and legislature of each of the states, and all local or other authorities within the territory of India.
So your local panchayat, your municipality, the district board, they're all the state in this context.
Every single one of them. It is a comprehensive command to every layer of power in the nation.
Okay, so we have the command. Now let's look at the content. The Constitution lists these principles from Article 36 to 51. But it doesn't really organize them with nice little headers, does it?
No, not at all. The text just runs sequentially. It can be a bit of a jumble if you read it straight through. But to make sense of the ideology behind them, constitutional scholars usually classify them into 3 broad buckets.
Right, the 3 categories.
Socialistic principles, Gandhian principles, and liberal intellectual principles.
I find that framework so helpful for getting a handle on them. Let's break down that first bucket, the socialistic principles. This seems to be where the heavy lifting for the welfare state comes from.
This was the core objective, you have to remember. For a country coming out of colonialism, the British Raj was a police state.
Right. Law and order, collecting revenue, that was the job.
Exactly. The Constituent Assembly wanted to transform India into a welfare state, where the goal is social and economic justice.
And Article 38 really sets that stage, doesn't it?
It does. Article 38 is the broad mandate. It directs the state to promote the welfare of the people by securing a social order where justice, social, economic, and political informs all the institutions of national life. It specifically talks about minimizing inequalities in income, status, and opportunity.
So it's the big picture goal.
Hmm.
But if Article 38 is the goal, then Article 39 feels like the strategy. This article seems to come up constantly in legal history.
Oh, Article 39 is the engine room of the socialist directives. It's practically a list within a list. It calls for the right to an adequate livelihood. But the real friction points, the ones that cause all the legal battles later, are clauses B and C.
Let's look at those specifically, Article 39B and C.
Okay, so Article 39B directs the state to ensure that the ownership and control of the material resources of the community are so distributed as best to serve the common good.
Distributing material resources.
Okay. And then Article 39C gets even more explicit. It says that the operation of the economic system must not result in the concentration of wealth and means of production to the common detriment.
Wow. That is extremely specific. It's basically a constitutional mandate against monopolies and the hoarding of wealth.
It is a direct instruction to redistribute resources if necessary. And this bucket also covers labor rights in a big way. Article 39D mandates equal pay for equal work for both men and women.
Something we're still discussing globally today.
Absolutely. Then Article 41 secures the right to work and public assistance in cases of unemployment or old age.
And Article 43 talks about living wage. That's an important distinction from minimum wage, isn't it?
It's a huge distinction.
Yeah.
A minimum wage is just about survival. Article 43 envisions a living wage that ensures a decent standard of life, full enjoyment of leisure, and social and cultural opportunities. It's a much higher bar.
And we even saw an addition to this bucket later on during the emergency with Article 43A.
Yes. The 42nd Amendment in 1976 added Article 43A. It directs the state to take steps to secure the participation of workers in the management of undertakings.
So the idea was that in a socialist democracy, workers shouldn't just be cogs in a machine.
They should have a voice in how the industry is run. That was the intent.
Okay, so that's the socialist bucket. Let's move to the second one, which feels very specific to the Indian context, the Gandhian principles.
This bucket really represents the national movement's legacy. During the freedom struggle, Mahatma Gandhi had a very specific program of reconstruction. He believed that the soul of India lived in her villages, not in the cities.
Right.
But the draft constitution, when it was first presented, was very modern, very centralized. There was a lot of concern among Gandhian members that his vision was being ignored.
So the Gandhian principles were a way to ensure those ideals weren't lost in the drive for modernization.
Precisely. And the most significant one, without a doubt, is Article 40. It directs the state to organize village panchayats and give them the powers they need to function as units of self-government.
The bedrock of local governance. This is huge.
It is. Then you have the economic side of Gandhi's vision in Article 43, promoting cottage industries on an individual or cooperative basis in rural areas.
And that was strengthened later too, right?
Yes. The 97th Amendment added Article 43B, which deals specifically with promoting cooperative societies.
Now, there are also some social directives in this bucket that often spark a lot of debate, like prohibition.
Right. Article 47. It directs the state to bring about the prohibition of the consumption of intoxicating drinks and drugs which are injurious to health.
Which is why we see states like Gujarat or Bihar imposing total alcohol bans. They're directly citing Article 47.
They are. And the other controversial one involved cows, Article 48.
Yes, Article 48.
It's interesting because of how it's framed. It directs the state to organize agriculture and animal husbandry on modern and scientific lines, but then it specifically adds
The second part.
the second part, and shall, in particular, take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draft cattle.
So it blends this idea of scientific agriculture with a very specific cultural and, well, sentimental preservationist stance.
It does, and that duality has made it a flashpoint for litigation and politics ever since it was written.
Okay, let's hit the third bucket. The liberal intellectual principles. This sounds like the modernization squad.
That's a very fair description. These principles align with Western liberalism. The goal here is a modern, progressive, uniform state. And the headline act here, the one that generates the most headlines today, is Article 44.
The Uniform Civil Code, the UCC.
The state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. The idea is to have one single law for marriage, divorce, inheritance, adoption.
That applies to everyone, regardless of their religion.
Exactly. Which is obviously a massive departure from the current system of personal laws based on religion.
A huge departure. And we'll definitely circle back to why that one remains largely unimplemented.
You will. But this bucket also includes Article 45. Originally, this article was about something else. It directed the state to provide free and compulsory education for all children until the age of 14.
But that changed, didn't it? Because education became a fundamental right.
It did. The 86th Amendment in 2002 was a landmark. It moved education into Part 3, making it a fundamental right under Article 21A. So Article 45 had to be modified.
So what does it say now?
Now it focuses on early childhood care and education for children below the age of 6.
Then there's the environment. I feel like most people don't realize the environment is explicitly mentioned in the Constitution as a goal.
It wasn't originally. It was another addition by the 42nd Amendment in 1976. Article 48A directs the state to protect and improve the environment and to safeguard the forests and wildlife of the country.
And finally, a big one for the rule of law. Article 50, separation of judiciary from the executive.
This is absolutely crucial. In the colonial era and even in the early years of the Republic, district collectors often had judicial powers. They were the executive, but they could also be the judge.
They could arrest you and then sentence you.
That's the problem. Article 50 said, separate them. You cannot have the prosecutor and the judge be the same authority. You need that firewall.
So we have this incredible wish list. A welfare state, empowered villages, protected cows, a uniform civil code, a clean environment. But here is the elephant in the room. Article 37.
Article 37, the disclaimer clause.
It says, these provisions shall not be enforceable by any court. So, if I don't get my living wage, or if the environment around me is dirty, I can't sue the government under Part 4.
That's correct.
So if these are the conscience of the Constitution, why did the framers make them? We're toothless. Why not make them binding, just like fundamental rights?
It wasn't because they didn't care. It was because they were intensely practical. The framers in 1949 faced two massive constraints. First, and most obviously, money.
The financial reality of a newly independent post-partition nation.
India was incredibly poor. If you made the right to work or the right to education instantly enforceable in court, the state would have gone bankrupt on day one. You can't sue a government for resources it literally does not have. They needed time to build the economy.
Okay, that makes sense. And the second reason?
Diversity and social backwardness. The country was vast, diverse, and steeped in tradition. If you tried to impose a uniform civil code or ban child labor instantly across every remote village,
you might have caused a backlash that could break the new nation.
Exactly. They felt the state needed flexibility in timing and application. They didn't want the new state to be crushed under the burden of mandatory enforcement from day one.
So the logic was, we absolutely want to do this, but we need to choose the time and place. But if there is no legal sanction, what stops the government from just ignoring these principles and treating them like garbage?
The sanction is political. The real force, as the framers saw it, isn't the court. It's the electorate. It's public opinion.
So you vote them out.
That was Dr. Ambedkar's argument. He was very clear on this. He said, a government which rests on popular vote can hardly ignore the directive principles while shaping its policy. If they ignore them, they will have to answer for it at election time.
Aladi Krishnaswamy Iyer had a similar view, didn't he? I remember a quote from him.
He did. He famously said, no ministry responsible to the people can afford lightheartedly to ignore the provisions in Part 4.
That is a very optimistic view of how democracy works. But surely, not everyone in the Constituent Assembly bought that. The critics must have had a field day.
Oh, the criticism was absolutely savage. K.T. Shaw is probably the most famous critic. He's the one who gave us that memorable line about the DPSP being a check on a bank payable only when the resources of the bank permit.
Basically calling it an empty promise.
An empty promise. Then you had Nasiruddin, who compared them to New Year's resolutions, made on January 1st and broken on January 2nd.
Ouch. That hits a little too close to home.
And T.T. Krishnamachari, who was a member of the drafting committee itself, he called them a veritable dustbin of sentiments.
A dustbin of sentiments. From a guy on the inside, that is harsh.
There was also a more technical critique about the arrangement, and Srinivasan pointed out that it was a bit of a mishmash. You have these vital economic issues like wealth distribution right next to, sentiment-based ones like protecting monuments.
It's not logically structured.
It isn't. And Sir Ivor Jennings, the famous British constitutional expert, was very critical. He said Part 4 expresses Fabian socialism without the socialism, and that the ghosts of Sidney and Beatrice Webb stalk through the pages.
So he was basically saying it was based on 19th century English philosophy that might not fit 20th century India.
Exactly. He wondered if these 19th century ideas would still be suitable for the 21st century.
Well, here we are in the 21st century, and we're still debating them, so maybe he had a point. But the real drama isn't just in the criticism. It's in the legal battles. Because even though you can't enforce them directly, these principles picked a fight with the one part of the Constitution you can enforce.
This is the legal battlefield. This is the defining conflict of Indian constitutional history. It's Part 3, justiciable fundamental rights, versus Part 4, non-justiciable directive principles.
Right. So Part 3 says, I have the right to property, or I have the right to equality. Part 4 says, the state needs to redistribute wealth for the common good. So what happens when the government takes my land to redistribute it?
That is the core conflict. And it started right away. In 1951, in the Champakamdor Rajan case, the Supreme Court took a very strict legalist view. They said fundamental rights are supreme. The directive principles are subsidiary. If there's a conflict, Part 3 wins, period.
But the court also said that Parliament could amend the fundamental rights to make way for the principles, right?
Yes, and that's what happened. Throughout the 1950s and 60s, Parliament passed amendments. The 1st, the 4th, the 17th, chipping away at the right to property to implement land reforms. But then came the Goloknath case in 1967.
This was the turning point.
A huge turning point. In Goloknath, the Supreme Court reversed its earlier position and ruled that fundamental rights are sacrosanct. They said Parliament cannot take away or abridge them. Full stop.
So you can't amend fundamental rights, even to implement directive principles.
That's what the court said. And it created a deadlock. The government is being told you have these instructions in Part 4 to fix the economy, but you can't touch Part 3 to do it.
Parliament must have been furious.
They were. They retaliated with the 24th and 25th Amendments in 1971. And this is where they introduced a new article, Article 31C. This one is crucial.
Let's unpack Article 31C. It acts as a kind of shield, doesn't it?
It's a shield specifically for the socialist principles. Article 31C said, if a law is made to implement Article 39B or 39C, remember, those are the ones about distributing resources and preventing concentration of wealth, that law cannot be declared void just because it violates Article 14, which is the right to equality, or Article 19, the right to freedom.
So it basically created an exception, saying, for these specific socialist goals, directive principles can override fundamental rights.
Correct. But then they got greedy. The second part of Article 31C said, and no court can even question whether the law actually achieves those goals. They tried to strip away judicial review entirely.
Just trust us, we're the government. I'm going to assume the Supreme Court did not take that lying down.
Enter the most famous case in Indian history, Kesavananda Bharati in 1973. The basic structure case. The Supreme Court, in a very long and complex judgment, struck a delicate compromise.
What was it the deal they offered?
They said, okay, Parliament can amend fundamental rights. So they overruled Goloknath. However, they said judicial review is a basic feature of the Constitution, and you can't take that away.
So they kept their power.
They did. They struck down the second part of Article 31C that barred the courts from looking at the laws, but, and this is key, they upheld the first part. Laws implemented for Article 39B and C can override Articles 14 and 19.
So the shield remained, but the courts kept the right to peek behind the shield to see if it was legitimate.
A perfect summary. But the fight wasn't over. During the emergency, the government tried again with the 42nd Amendment in 1976. They tried to expand that shield to cover all directive principles, not just 39B and C. They wanted to give all directives supremacy over Articles 14 and 19.
In the court's response to that power grab.
That came in the Minerva Mills case of 1980. The Supreme Court said no. They struck down that broad extension. And they established what we now call the bedrock doctrine.
I love that imagery. The bedrock.
The court said the Indian Constitution is founded on the bedrock of the balance between fundamental rights and directive principles. They're like two wheels of a chariot.
You can't have one without the other.
Exactly. To give absolute primacy to one over the other is to disturb the harmony of the Constitution.
So after all that fighting, where do we stand today? Neither is superior.
Conceptually, they are complementary. Fundamental rights give you political democracy. Directive principles give you social and economic democracy. You need both to move the chariot forward. But practically, in a courtroom, fundamental rights enjoy supremacy, except for that very specific court-approved cutout for laws implementing Article 39, B, and C.
Okay, so we've had the philosophy, we've had the high-stakes court drama. Now let's talk about the reality on the ground. Have these principles just been pious aspirations, like the critics said, or have they actually changed anything for people?
If you look at the statute book, the critics were wrong, plain and simple. A massive amount of Indian legislation is a direct implementation of Part 4. The check is actually being cashed, maybe installment by installment, but it's being cashed.
Let's run through the list then. What are the big legislative wins for the DPSP?
Well, start with the economy. The Planning Commission, established in 1950, and its successor, NITI Aayog. The entire concept of five-year plans was essentially an administrative framework to implement the socialist principles and secure socioeconomic justice.
And land reforms. That was a huge part of the early decades.
Huge. The abolition of intermediaries like zamindars, jagirdars, and inamdars. The imposition of land ceilings. Distributing surplus land to the landless. This was a direct application of Article 39, preventing concentration of wealth and distributing resources.
What about on the labor and welfare front?
The list is almost endless. The Minimum Wages Act of 1948, the Maternity Benefit Act of 1961, the Equal Remuneration Act of 1976, the Child Labor Prohibition Act of 1986. These aren't just random laws. They are the legislative fulfillment of Articles 41, 42, and 43.
You mentioned legal aid earlier. That was a later addition, Article 39A.
Yes, and it led directly to the Legal Services Authorities Act of 1987. This created the entire system of look adalets, which are people's courts for settling disputes cheaply and quickly. This ensures that equal justice isn't just a theoretical concept for the rich.
And the environment. We talked about Article 40AA being added.
Which gave us the Wildlife Protection Act of 1972 and the Forest Conservation Act of 1980. These landmark laws gave real teeth to the environmental directive.
What about that big Gandhian dream, the panchayats, Article 40?
That one took a long time, but it finally happened in a big way. The 73rd Constitutional Amendment in 1992 gave constitutional status to panchayats. It finally translated Article 40 from an aspiration into a concrete three-tier reality of local self-government.
And protections for weaker sections, Article 46.
We have a robust, if often debated, system of reservations. But beyond that, look at the Protection of Civil Rights Act of 1976, the SCST Prevention of Atrocities Act of 1989. And very recently, the 103rd Amendment in 2019, which introduced the 10% EWS economically weaker sections reservation. That's a direct implementation of Article 46.
Even the separation of judiciary from the executive, Article 50, that was achieved, right?
It was through the Criminal Procedure Code of 1973. Before that, administrative officers had judicial power. Now, judicial magistrates are a separate cadre.
So they aren't toothless. They just have maybe delayed teeth. Or legislative teeth.
Legislative teeth is the perfect term. They need a law passed by Parliament or a state legislature to bite. But once that law is passed, they bite hard.
Now, before we wrap this all up, a quick question. Are there any directives hiding elsewhere? Or is Part 4 the only game in town?
That's a great question. There are actually a few hidden directives located outside of Part 4. They are also non-justiciable, but the courts give them equal importance.
Oh, interesting. Where are they?
Okay, in Part 16th, which deals with special provisions for certain classes, you have Article 335. It says the claims of scheduled castes and scheduled tribes to services and posts shall be taken into consideration. But it adds a crucial balance.
There's always a but.
There is, consistently with the maintenance of efficiency of administration.
Ah, and that efficiency clause is always a major point of debate in reservation cases.
Always. Then, in Part 77, on official language, we have Article 350A. It says every state should endeavor to provide instruction in the mother tongue at the primary stage of education for linguistic minorities.
That's a huge one for education policy debates.
A huge one. And finally, in the same part, Article 351. This makes it the duty of the Union to promote the spread of the Hindi language and develop it to serve as a medium of expression for India's composite culture.
Also a very lively topic of discussion, to put it mildly.
Indeed. But legally, these three articles function just like the DPSP. They are instructions to the state that shape policy, even if you can't sue over them directly.
Okay, let's try and bring all this together. We started with this paradox, a set of instructions that you can't enforce. But looking back at the last 75 years, it seems like Ambedkar's instrument of instructions has, by and large, actually worked.
I think it has. If you removed Part 4 from the Constitution, India might still be a democracy in form. We'd have elections, free speech. But we wouldn't be a democracy in substance. We wouldn't have the constitutional blueprint for a welfare state. These principles have been the moral compass for lawmakers.
They force the government of the day to constantly answer the question, what are you doing for the common good?
Exactly. And they facilitate stability and continuity. Even when parties change, the underlying goal of the state achieving social and economic justice remains written in the Constitution. It allows the opposition to hold the government accountable to a constitutional standard.
You promised a welfare state. It's right here in Article 38, so where is it?
Precisely.
Here's my final thought for you listening. We've talked about how the government has, over time, picked and chosen which principles to enact. We got panchayats from Article 40, we got environmental protection laws from Article 48A, we got reservations from Article 46.
Yes, many have been acted upon.
But consider the Uniform Civil Code, Article 44. It has been sitting there in the text since 1950, just as valid as all the others.
And it raises a provocative question. Why has that specific directive remained, for the most part, a dead letter for so long, while others were enthusiastically enacted?
Is it simply too politically sensitive? Is there something fundamentally different about that particular directive? And as India continues to change, will we see what was once called a dustbin of sentiments finally become the law of the land?
That's the question that really defines the difference between a static constitution and a living one. Are some principles meant to remain aspirational forever?
Something to chew on. If you want to read the specific articles we mentioned, especially that crucial list in Article 39, do check the show notes. We have laid them all out for you.
It's always good to go back to the source text.
Absolutely. Don't forget to like and subscribe to the channel Deep Dive Daily for more insights like this. Thanks so much for listening.
Thank you. Goodbye.